Closed captioning for Lakeland Currents is supported by the Minnesota Department of Commerce, Telecommunications Access Minnesota, and Nisswa Tax Service. Nisswa Tax Service, tax preparation for businesses and individuals. Across from City Hall in Nisswa and online at nisswatax.com.
Hello again, everyone, and welcome to Lakeland Currents, where we're talking about a topic that I think everyone will find interesting. I know I've really learned a lot just in doing some of the background research on elder law. And elder law is the changes, the things that affect us when people have property, money that they want to pass on to loved ones, and sometimes they want to use for nursing homes or whatever the circumstances in their lives might be. Very complicated. Lots of things happening in this state that I think you'll find very interesting. My guest today is Michael Brouse, who is an attorney at law out of Fosston, Minnesota. And he's not a specialist in this area because he said there is no such title as a specialist in elder law. But he has been practicing in this field for 30 years and has gained a lot of knowledge. And so welcome to the show, Michael. It's good to have you here.
Thanks, Ray.
Hopefully driving our last day through snow.
Hopefully, yes.
Well, tell us a little bit about what is elder law.
Well, elder law for the practice of attorneys really involves a number of different areas. Basically, if you were to put it in a broad focus, it would be dealing with the issues that elderly face as they begin to, say, post-retirement, as they begin to age. And those issues include things like estate planning, of course, deciding what it is that you want to do with your estate or have happen to it after your death. But I think just as importantly, and maybe even more importantly in many cases, is dealing with the issues that come with incapacity. In the event that you have a medical issue, you find that you're no longer able to deal with some of the routine issues of life, then sometimes the area of elder law involves helping clients find the kind of care that they need, including finding some of the facilities that can provide that care. In many cases, it involves directing clients to the kinds of programs that will help them, either from a medical perspective or from a financial perspective, deal with those kinds of issues that do come with aging. So it is a broader area than just estate planning. And that's something I think most people don't realize. I think they think of elder law in terms of, planning for death, when actually planning for incapacity is probably as important, if not more important, for many people.
And you said that this is not an area where a lot of lawyers spend their time.
Yes, the part of elder law that deals with estate planning, I think you'll find that there are a fair number of lawyers that do that. But when you begin to get into the area of elder law that addresses issues involving incapacity, there you find that the number of lawyers who are familiar with the kinds of laws and the programs that deal with those particular issues, those lawyers are few and far between. Partly because that area has become so complex, and partly because it's an ever-evolving area. We have a legislature that is very active and is enacting legislation, it seems, on a continuing basis, changing the laws, changing the programs that apply. And so it's very difficult to stay current. And frankly, for example, since that is an area that I focus on, as I told you, it's not a recognized specialty, but it is a specialized area. Because of that, that's 90% of what I do. I don't have time to practice in other areas of law. And I think that's true of most elder law practitioners who deal in the, let's say, subspecialty area that I do, which is focused primarily on addressing people's financial issues when it comes to long-term care, nursing home placement, for example.
We're going to talk in a little bit about people who have cabins or farms.
Yep.
Homes, and they're figuring out ways to leave this maybe to their children. Mm-hmm. And I think it's fair to say also that sometimes when things happen to people, they're not necessarily old. They could be 35, they could be 45.
True. That's a good point.
And sometimes they're not prepared for the consequences. And I think we've all heard stories of people who have lost everything they owned to the nursing home. I mean, the nursing home care is taking all of the money that they've had. So we're going to talk a little bit about that as we go through this program.
Okay.
But maybe we could just talk just really briefly about long-term care. the
Okay.
insurance itself. What can you tell us about long-term care insurance? Is it adequate to help people? Is it inadequate? Are most people preparing for this? What are you seeing?
I think what people have to understand about long-term care insurance, particularly in the state of Minnesota, is that it is one arrow in the quiver. Certainly, it's a tool that can be used to alleviate some of the financial pain that people are going to suffer if they find themselves in a nursing home. But as a general proposition, people are going to be very ill-advised to rely on long-term care insurance to cover all of their long-term care needs. That just is not going to happen. So they have to look at it in the context of their particular situation and what the benefits are that that insurance will afford them relative to the costs. And as you may be aware, it seems most people are these days, long-term care insurance is becoming increasingly expensive. So you have two issues there for people who are thinking about long-term care insurance. In addition to the fact that it doesn't provide total coverage, number one is the cost. Many of the clients that I have who are middle class or even lower middle class are not people who can afford long-term care insurance. Secondly, the underwriting requirements for long-term care insurance are far different than those for like life insurance. So by the time people begin thinking about the need for long-term care insurance, they find that they won't medically qualify for it. So it's something certainly worth considering, but you have to understand that it may or may not be an option that's available to you.
Well, and I know a lot of this can become pretty complicated, sophisticated, but if you were to take a person, we live in a large lakes area, mm-hmm. and a husband and wife have a cabin, mm-hmm. and they've got a daughter and a son, and they're going to maybe give this cabin to their children when they're getting ready to not use it so much, or maybe they're going to go to the nursing home. What are the issues that you're seeing here that are raising red flags?
Well, frankly, people in this state, and I think many other states, but Minnesota has become particularly harsh with respect to the financial implications of long-term care, or people who are facing admission to a nursing home for long-term care. The issue is how do they preserve that cabin for the family and at the same time meet the needs, the financial requirements that accompany long-term care. It's not unusual for me, for example, to have clients who are spending $70,000 or $80,000 a year for long-term care costs. And again, because most of my clients are either middle class or lower middle class, it doesn't take very long before whatever assets they have are essentially drained.
When you say they're spending $80,000 a year, you mean in the nursing home?
For the long-term for long-term care nursing home care, right?
Not the insurance.
Not the insurance.
Okay.
Okay. Good. So, as you can imagine, given where I practice, which is where the prairie meets the pines, that's the expression mm-hmm. for Boston. We're on the edge of lake country, and we're on the edge of ag country. So many of the cases I have involve ag land, which oftentimes families want to keep in the family, and secondly, lake cabins. Lake cabins now have become basically an heirloom. It's something that the current generation that owns that cabin wants to pass on to succeeding generations. The problem is that if one of the parents who owns this lake home finds themselves in a nursing home, and we'll assume that the lake home is a cabin and not their primary residence, that lake home is then what's called a non-excluded asset under the law. And I won't take you too far into the weeds on the law here, but the basic premise is that if we have a couple, once a spouse goes to a nursing home, that first date is the date at which at some point social services will look at all of the assets that couple has. And based on those assets will determine what the community spouse, that is the well spouse, is able to retain and what is required to be spent for the ill spouse. A lake home is a non-excluded asset. Excluded assets, frankly, are your house, one vehicle, and a funeral and burial plan if you have it properly set up. The community spouse is able to keep 1/2 of then all of the non-excluded assets up to a maximum of just about $116,000. Well, obviously most lake cabins that you see in Minnesota are going to be worth far more than that. To the extent then that you have these excess non-excluded assets, they have to be what's called spent down towards the care costs of the institutionalized spouse. Well, what that means is if you have a cabin, a lake home, or you have ag property that exceeds that $115,000 cap, you will have no choice but to sell it and then begin spending that money towards the care costs of the institutionalized spouse. Now, that $115,000 is a cap. The community spouse gets to keep 1/2 of those non-excluded assets, but up to that maximum of $115,000, $116,000. So most lake cabins then are obviously at risk of loss if one spouse requires long-term care and doesn't have sufficient resources to meet their care costs. And frankly, the area that the geographical area in which I practice is probably the northwestern 16 counties of Minnesota. Most of the clients that I have do not have large pension plans, they don't have large retirement plans, and frankly they're living on Social Security and maybe a little bit of savings. And it is a rare case that I have a client who has the income that is sufficient to meet those care costs. So as a result of that, to put it in ag terms, they will be eating into their seed corn very early on.
So theoretically, a husband and wife could give a cabin to a son, and if they are not over that 5-year period, that could be that that son ends up paying part of that cabin expense to their health care. Is that how I'm understanding that?
Well, not quite. Of course, the first thing that would come to most people's minds is that if they're going to protect that lake home or that lake cabin, they should give it away. Well, on the surface, that's a good idea, but it does come with certain difficulties. And the reason is because when you give things away, that is, you get nothing in exchange for them, no consideration, you make a gift. That's what's called in the Medicaid law, which is the law we're dealing with here, an improper or prohibited transfer. And the consequence of that transfer is that because you've given this away, for some period of time you are going to be ineligible for Medicaid to cover your long-term care. And the length of that period of time depends entirely on the value of what you give away. So for example, you could give away a lake cabin and find yourself ineligible for long-term care for, let's say, 120 months or 80 months. It all depends on the value. And the difficulty is that that ineligibility period that flows from that transfer doesn't begin until the person who has made the transfer, or the person's spouse, is what's called otherwise Medicaid eligible, which means their assets already have to be reduced to a very minimal level and they have to be in need of long-term care services. So you could have a situation where you've transferred a cabin 3 years earlier, then one spouse goes to the nursing home, and it's not until that spouse goes to the nursing home that that ineligibility period will even start. The 5-year period that you made reference to is what's called the look-back period. So from the time a spouse goes into the nursing home and makes an application for Medicaid, and let's say that they are otherwise eligible, in other words, their assets have been reduced to minimum levels, the financial worker at the County Social Services Agency will look back to determine whether or not you have made any transfers within 5 years. If you have, then that ineligibility period will be calculated for that transfer. If the transfer falls outside of that 5-year window, then it's not taken into account. So there's 2 periods of time that people have to be mindful of. One is the ineligibility period, the other is the look-back period. And there is an interplay between those, and it's something that when most people get involved with a long-term care situation, they will hire an attorney who works in this area to sort out the interplay between the 2 time periods.
It can be pretty complicated.
It can be very complicated. You know, that's what's interesting is you're dealing with a Medicaid program that pays for long-term care.
That's federal.
It's essentially federal, but it's administered by the states. In the state of Minnesota, it comes under what's called the MA program, or Medical Assistance Program. But the irony of it is, if you are middle class or essentially middle class, you are going to be well advised to retain the services of an attorney to help you through this, because it is complicated. Many of the laws that we're facing now have been recently enacted by the state legislature. and are now subject to interpretation. And therefore, we find that in many cases, even the county financial workers don't know how to properly construe the laws and apply them to particular cases. So sometimes my job is less of a planning situation in terms of planning in advance than it is dealing with a crisis situation. And then beyond that, it's dealing with a mistaken interpretation of some kind that has been made by a county financial worker. And again, I have some sympathy for the people in that situation because things have become so complex and are so fluid that it is very difficult to stay on top of this area of the law, which of course again is why those of us who practice in this area pretty much focus on just this area of law.
Now you have a special case that you're working on.
Yes.
That you feel could go to the state Supreme Court, could even theoretically go to the federal Supreme Court. Could you just explain to us a little bit about what
Sure.
that is you're doing?
Sure, and this is an illustration of the kinds of things that we're dealing with here. And let me back up just a little bit. And I'm going to give you my personal opinion as a practitioner who's been working in this area for nearly 30 years. We're dealing with a state agency here, the Department of Human Services, which we refer to as DHS, which, in my opinion, has become an imperial bureaucracy. This is an agency that writes the statutory proposals for the legislature, then after the statutes are enacted, writes the rules by which those statutes are interpreted and applied, and then employs the judges, the administrative law judges. They're not judges in the judicial sense, they're simply attorneys who have this position of administrative law judge, then pays the salaries of the attorneys who interpret the application of those laws anytime there's a dispute. So when I say this is an imperial agency, when you get to write the rules, when you get to interpret the rules, and you get to then determine how they're applied, you have the imprimatur of an imperial agency. There's no checks or balances there. So what happened in this case is that the DHS simply changed the rules that apply to clients who have life estates and who have a spouse in the nursing home. And to make this simple, up until this change in agency policy, life estates were not counted for purposes of determining whether a person had excess assets and was therefore ineligible. And it was not counted because under the federal law, an asset, in order to be counted, has to be an available resource that can be liquidated and spent towards a person's care costs. Well, a life estate has never been that kind of asset because the life estate holder, the parents typically, can't sell it. There's no market for those. So they were never counted. Some bureaucrat in DHS then drafted a memorandum which said that, yes, life estates in non-homestead property will be counted for eligibility purposes. And it was my clients who faced the first case in which this had to be dealt with, in which we had to take an appeal, in which the administrative law judge said, yes, I'm going to permit the agency to just change the rules. Well, our argument is, number one, under federal law, which preempts state law, an asset is not a countable resource unless it can be liquidated and used to pay for care costs. The evidence in this, the only evidence of record in this case, was that this life estate was not saleable. As we've known for 30 years, that's the way they've always been treated. Secondly, our argument was that DHS simply up and changed the rules, the substantive rules that apply to eligibility, without going through the administrative procedures process. So the public never had the opportunity to have any input into this. The first time we knew about this policy change was when this undated, unsigned memorandum that had been prepared by some bureaucrat in DHS was distributed to the county agencies, and then of course I got a copy of it when my case came to the forefront and my clients were denied eligibility. So this case then involves federal law because it is contrary, we believe, to the mandates of federal law because of the way life estates are being treated and counted for eligibility purposes. We believe it's a violation of state law because the DHS did not bother to go through the Administrative Procedures Act. They simply issued an executive fiat and said, we're going to change the policy that has been in place for 30 years. What I find so ironic about it is that the judge who decided this case said that the reason DHS did not have to go through these administrative procedures was because it really wasn't a change in the rules, that the manual that has these, what he referred to as guidelines, aren't really rules. Well, the interesting thing is, there have been two prior cases, three prior administrative cases that had decided this issue and said life estates are not countable for eligibility purposes. The rules up until this memorandum all said that in the healthcare programs manual that life estates were not to be counted for eligibility purposes. But the judge said, well, these aren't really rules. Well, then the question is, what are they? Because this is what all of the social services agencies use to determine whether someone is eligible. And what's more, that manual is promulgated by the Department of Human Services. It's the rule book, it's the Bible, it's the gospel, it's what we all look to determine whether or not someone is eligible. So they simply, by fiat, changed the rules. So both in terms of the substance of the law and what they did, being it's contrary to federal law, and in terms of the state procedures that have to be followed when you make those kinds of substantive changes, we believe that DHS has really gone beyond its scope of authority in making these changes. And where this is going to come into play is for people who have lake cabins and ag land in particular, because these are in large measure going to be non-excluded assets. And so if they are now counted, in other words, if a person has a life estate that they put into place as part of their estate planning, and they are now going to be counted, those assets are going to preclude the parents, in many cases, from becoming eligible unless they sell that lake home or unless they sell that farmland.
So that being able to keep it in the family is going to be more difficult.
Right now it is in jeopardy for everybody in the state of Minnesota who may find themselves at any point in a nursing home. And you tell me who that is. I mean, you never know whether you're going to be in a nursing home or not. You don't ever know whether you're going to need long-term care. So the point is, now every single property owner who owns a lake cabin or non-excluded farmland is in jeopardy.
Wow.
And that's why this case is so fundamentally important. But here's the other part of the problem when you're dealing with DHS. I told you earlier when we were talking that there was a case that had been decided several years ago called the Bard case. That case did go all the way to the U.S. Supreme Court, and the Supreme Court refused to hear the case, which basically said, okay, the Minnesota Supreme Court got it right. That case, the legal fees for that case were extraordinary, as you can imagine. Tens and tens and tens of thousands of dollars. My clients and the kinds of clients that I serve, and most elder law attorneys serve, do not have those kinds of financial resources. So whenever DHS changes the rules in a way that we believe, and they've done this year after year after year, keep in mind, I've been doing this for 30 years, it is the rare case where they are ever challenged beyond the administrative level because the people that we represent do not have the financial resources to carry on that fight. DHS has an unlimited war chest. And when it comes to a matter of statewide importance like this, they are not afraid to open the war chest and take out whatever is necessary to take the distance. Because they know that somewhere along the line, unless these clients have far more resources than most, that the clients are going to cave in. And frankly, if you were to look at all of the case law that's reported in the books, okay, of judicial decisions, a minuscule portion of those cases would involve the kinds of issues that we face in elder law. And that's because people don't have the resources to take on DHS, and DHS knows it. The other thing they know is this. As in the Bard case, even when the resident, or my client, for example, even when we win, we cannot recover those fees. So we need support from outside sources in order to carry on this particular fight. And because of the things that the state legislature did in 2009 at the behest of DHS, this is but one of many cases involving fundamental rights of people in this state that is going to go up on challenge in the court system if we can find the resources to do that. And I'm going to put in a plug here. This case that we have, because of what we've already invested in it and because of the fees that are already being carried by my law firm and the other law firm that's involved in it, we are soliciting financial support, both from other attorneys as well as from ag groups. We're hoping that some lake cabin owner associations will become involved in this eventually, but if anyone who is concerned about this and concerned about protecting their rights wants to contribute to this, they're welcome to call me, and my phone number is 218-435-1661.
We're about out of time, but if people are referring to this, they want to get more information from lawyers, legislators. What is it called? What would they refer to?
All they have to do is call my office, because I can provide them with first of all, an executive summary of the issues that are involved here. As you know, it's a very short 1.5 page document. I'm more than willing to provide them with both the administrative law judge's decision as well as our brief and any other materials that they want that might be of interest to them with respect to this case.
So it's something we should all be concerned about because it impacts every Minnesotan, and not necessarily calling the legislature is necessarily that's a solution, but start with you. We'll say to start with you, and you can refer people on from that point on.
Yes, and we have to get this through the court system, because that is where historically we've been able to get relief from statutes which are either unconstitutional or contrary to federal law.
All right. Michael, thank you for appearing on our show. Maybe we've opened up more questions than we have answers, but I think it's something that people certainly need to be aware of. Again, I've been talking with Michael Brouse. He's with the law firm Brouse, Woodkey, and Meyer in Fosston, Minnesota. And good luck with this project. It sounds like you got your hands full.
We do definitely, Ray. Thank you.
You bet. You've been watching Lakeland Currents, where we're talking about what you're talking about, and this is our last show of the season. It's time to go fishing. We'll see you in the fall. So long.